and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
And that's where, in my opinion, she fucked up. Criminal Procedure Rules 27 verdict. The two or more offences or defendants tried together, the jury may consent to the judge at any time during the deliberations return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges as to which the verdict has been reached. It was purely within her power to actually have them return the verdict on 1 and 3. She just decided she didn't want to. The judge may declare a mistrial as to any charges upon which the jury cannot agree to a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. As far as I'm concerned, the verdicts for counts 1 and 3 should have been entered and recorded.
Fourth Karen Reed juror confirms a unanimous not guilty on murder, attorneys say. Fourth Karen Reed juror. So far, we're up to 1/3 of the jurors have come forward and said she was unanimously found not guilty on the murder charge. Well, Karen Reed's attorneys on Wednesday filed a new memo in support of dismissing 2 of 3 counts against her after her last week's mistrial, saying that a 4th juror has come forward claiming that the jury was in full agreement of not guilty on 2nd-degree murder.
I can understand why a jury would have looked at this form, returned it to the judge and said, hey, we have some irreconcilable differences here. We believe we are genuinely hung on the basis of this form. In my professional opinion, this is a terrible form. Each of these should have had a guilty of this offense, not guilty of this offense, guilty of this offense, not guilty of this offense. Because we have to treat everybody as if they are in 1st grade. Everybody needs to have their hand held, and everything needs to be made very clear for everybody. So I can fully understand that after the fact, we've got 4 jurors coming out saying, yeah, no, we did come to a conclusion.
Breaking news with Mark Betterow to bring you Commonwealth's opposition to defendant's post-trial motion to dismiss. I haven't even looked at it yet. Have you?
Yeah, it's what you'd expect. It's written by zombies for zombies, and I mean, they make fair legal arguments, but they just don't know how to read the room and are tone deaf about the most basic constitutional rights. They could oppose this, but in a way where they have a little bit of class in how they do this. And not to jump ahead too much, but I think what's going to happen is ultimately, if the judge denies all this on the papers, the people who are going to be offended more than the Karen Reed supporters, more than the defense, are going to be the jurors, who are going to be denied an explanation of what happened, because they're the people, if this gets denied, who have to live with the fact that we acquitted a woman who may very well get retried for murder. And that's a hell of a thing to have on your conscience, I would think. And if the judge doesn't want to hear it and the DA doesn't want to hear it, then there's no one left to hear it other than the public. And I think that's what ultimately is going to happen.
Bullshit. I almost said bullshit.
Almost.
I mean, look, let's face it. Most prosecutors with the last name Morrissey seem to be shit in most instances at this point.
The law is very much not on the defense's side in this, because opening into jury deliberations is sacrosanct. But does the law allow for the narrow question of asking them what their verdicts were? Maybe.
Subdivision permits a jury in multiple defendant or multiple offense cases with the consent of the court to return a verdict at any time during the deliberations with respect to the charges or defendants as to which a verdict has been reached. This rule also permits the court to require the return of such verdicts before the jury has reached a verdict as to all of the defendants or the charges. In either case, if the court directs the jury to continue its deliberations after rendering the verdicts under this subdivision. To the extent that this rule permits the jury to return such verdicts without having reached a decision on all charges of the defendants, it is consistent with the federal rules, the Court Rules of Criminal Procedure, Rule 535 C and D, from 1974. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree upon. However, it must first receive and record the verdicts which the jury can agree upon. So if the jurors that are coming out saying, yeah, we agreed, we said that it was unanimous, charges 1 and 3 were out the window, she should have at least told them it was an option to find what they agreed upon and left the rest blank.
And all of it is so fucking confusing to me because in the jurisdictions that I worked in, the jury instructions all said some or all. When you come to a result on some or all, that was the language of the jury instructions. So I practiced in a jurisdiction where split verdicts weren't uncommon. So it's frustrating that Massachusetts, the jury instructions don't say some or all, but the jury instructions are written by committees of lawyers and judges.
Allow me to break here to read to you the Massachusetts Government Superior Court Model Criminal Jury Instructions Final Charge Script Master Template. There are 3 different indictments or charges in this case. You must decide whether the defendant is guilty of each charge separately. For each charge, there are certain things the Commonwealth must prove beyond a reasonable doubt to show the defendant is guilty. I will explain these legal rules to you now. Indictment number 1, murder in the second degree. Indictment number 2, manslaughter while operating a motor vehicle under the influence. Or a lesser included offence, involuntary manslaughter, or a lesser included charge of motor vehicle homicide while under the influence. And indictment number 3, leaving the scene of an accident resulting in death. For each charge, you must decide whether the Commonwealth has proved, beyond a reasonable doubt, that the defendant is guilty of that specific charge. You may not find the defendant guilty on any charge just because you think the defendant did something else that was wrong or improper. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive 1 verdict slip for each charge. When all 12 jurors agree on the verdict for a particular charge, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of that charge beyond a reasonable doubt, then you should find that the defendant is guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove 1 or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge.
Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Reed does not have to testify, call, or question witnesses or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. The burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. What is proof beyond a reasonable doubt?
Just to be clear, Aunty Bev cut it way short. At no point does she explain each charge, or that each charge is on a separate sheet and how to deal with them. Anyway, back to our regularly scheduled program.
And those jury instructions are fought over. How many of you have watched with me as we've gone through jury instruction litigation? The jury instruction litigation in Depp v. Heard was extensive. Lots and lots of back and forth in that litigation Jury instruction litigation is one of the critical parts of trial. The attorneys submit jury instructions to the court, different sides, and then they go through and argue about the language of the jury instructions. They object to jury instructions. They can appeal based on objections to jury instructions.
Well, number one, he probably knows that this motion is going to get denied. He's preserving it for appeal. By the way, as this case is in appeal, and this could be an appeal for a couple of years, they cannot recharge her until the appellate decision is resolved. So there's that. Which leads us to the very real scenario that Karen Reed might be in her 50s before they retry this case. And as crazy as this case was with people not, butt dials and all of that, imagine how crazy it's going to be, 6 years down the road when everybody's like, you know what, man, do we have to? Or,
we have to go through this again.
Another lack of self-awareness. Very zombie-like is the word that we've used repeatedly with these people. And just, it's going to invite more criticism for them. And if it's denied out of hand, which, that's a possibility, I think it's just going to invite more criticism, including coming from jurors as well. I'm losing my voice. I'm a little sick, so just bear with me. Anyway, I don't think it was a great response. I don't know why they wouldn't have just said, let us make these arguments out of an abundance of caution. Let's see where the evidence goes. And then at a later time, we reserve the right to make the arguments that we're making. But, once again, they don't have any real care about anything other than potentially retrying someone for an offense for which they may very well have been acquitted for. And that's, that's just disturbing, but it's not surprising with these people. So what do you say?
They just missed the point. It's frustrating as I read it for the 100th time. I don't think they're getting into the deliberative process of the jury.
There is a lot of case law about opening into deliberations and questioning jurors about deliberations. And all of the case law is tremendously clear. You cannot question jurors about their deliberative process. Whether asking them the split of votes in Massachusetts counts as questioning them about deliberative process, I think is open for argument. And I think that would be interesting to see legally.
Or the jurors have a question, and then before you ever get there, they will give you a document. This is the question, and then you have a chance to consider, and then they hold a hearing, and then that's how they do it. So it's significant because number one, you need time as a attorney to process what the juror is asking, to consider whether or not we're going to object or recommend certain things or request certain things. But to do it and just read it in open court and then just make a decision
Right there
is kind of out of bounds. It's not illegal, but it just seems like you shouldn't do that. But it's not against the law. I mean, I guess she was well entitled to do that. It just,
To imply that it was almost unethical for the defense to speak to the jurors in the way they did after they got contacted by them, I think is laughable. I mean, they're zealously representing their client and trying to prevent a retrial on a possibly acquitted murder charge. That's what lawyers do. And that's what you would want your lawyer to do. And you would want a prosecutor to at least have some respect for the constitutional rights of the defendant. And in this county, they pretty much don't.
I don't know if this can be fixed in any way other than the Commonwealth literally doing the just and proper thing and choosing not to retry those counts in light of all of this. And that might be really what the defense is hoping for here, is that once it is seen by the public, if they do inquire from all of the jurors and the jurors make it clear that the verdicts are rendered, the only solution might be that the Commonwealth chooses to dismiss those counts and not proceed. The goal of the Commonwealth should be, the goal of every prosecutor should be to do justice, not to win, not to convict someone, to show the jury the facts and let them render a verdict that is just.
The judge doesn't appear to be in complete control of this, or at least there's been nothing publicly said. as far as we know, she didn't issue a scheduling order for papers. Did she preclude the defense from writing a reply, or did they get a deadline? Because otherwise, I'd assume they're going to write something back.
Them are the stakes, man. Them are the stakes. So that's where we're at with the Karen Reed mistrial. Where do we go from here? I actually don't know. Obviously they're gonna have to make a ruling on the motion. I don't know what's going on behind the scenes to either corroborate Jackson's affidavit or Yanetti's affidavit. He wrote one too. I'm not gonna read it because we're already an hour and a half in, hour 45 minutes in. There's not really a clear-cut legal procedure or requirement for the jurors to be making themselves available without, I guess, a subpoena. Is the subpoena even legal under these circumstances? I'm not sure. In Massachusetts, I'm not sure. It's going to be difficult. There's a lot of things. It's readily apparent to me that there's a lot of things that could have happened that didn't happen. And should a mistrial have been declared? I obviously thought no. It makes all the sense in the world that this judge would have just pulled the juror. All right, what are we deadlocked on? What's the issue? You guys have had a weekend. And they were only deliberating for like an hour before she just declared, you know what? I think we're just going to be done. I'm not going to make you guys compromise on your morals. She took the juror's note at face value and made certain decisions that is going to create probably 3 to 4 years of additional litigation for no reason. When she could have just asked the jurors, hey, what do you think on counts 1 and 3? And then if the acquittals were on 1 and 3, is the Commonwealth really going to be pursuing her strictly on the basis of count 2? I don't know. Maybe they would have. Maybe they would have. But them are the stakes.
The prosecution has broad latitude on what doing justice means. And I wonder if the defense, both attorneys or former prosecutors, is pushing this publicly so that the prosecutor will have to listen to the public who they prosecute on behalf of. The prosecutor's office is for the people. And if the people feel that this is unjust, the prosecution should not proceed. I don't necessarily trust this prosecutor to do that.
What I get from this motion is absolutely they want to retry this case. Will something come up that makes them not want to? I don't know. But at this point, I think they absolutely want to retry this case on all 3 counts. Maybe they don't care about the last count, but they want that second-degree murder charge. If they didn't, they could at least save some kind of face, right? With everything we've been going through, all the Proctor stuff, all the Kevin Albert stuff, all the cop stuff, internal affairs investigation, suspensions with and without pay. If the Commonwealth stepped up and said, you know what, in the interest of justice, we want to do what's right. We're going to drop counts 1 and 3, but we basically won by a majority count 2. So we're going to retry that because the victims deserve it. The community deserves justice. And a majority of those jurors agreed with us that she was guilty. It could be an opportunity for them to have a good press release to save some face. But no, this Commonwealth is not going to do that.
Early next week, I think it'll be a very strong, aggressive response, both about their lack of regard for the ultimate issue, their, putting form over substance, saying you waive this argument, again, expressing no regard for the possible concern about trying her twice for murder if she was acquitted, which is crazy. I think if there's any other affirmations coming, they're going to get them out as soon as they can. If there's any other jurors that are forthcoming. But, I think a lot of prosecutors around the country would have said, we don't necessarily agree with this. We're going to, make the arguments, but out of an abundance of caution and transparency, given the allegations that have been raised, which appear to at least be credible on the face, we ought to take more evidence on this, see if the jurors are willing to confirm that this is the case. And if it is, you ought to have a hearing and then go from there.
If new stuff pops off, they may change their mind. But with what it is right now, they're full steam ahead is what it feels like to me.